Hi, I'm Darcel Lobo. I own Dow Law Firm, and today we're going to talk about the difference between a healthcare power of attorney and a financial power of attorney. Because sometimes you may have just heard of a general durable power of attorney, which includes everything. But here at Dow Law Firm, at my office, we actually do them separately because for a lot of my clients, someone who you want to handle your healthcare decisions may not be the same person that you want to handle your financial decisions, right? Those are two really different roles, and you may have different people that you entrust to handle those decisions for you. Sorry, that was my dog. That's Millie here, who you heard her collar shaking. So we're going to talk about the difference between the two because we keep them separate at my firm. I like them separate. I don't like them combined as one document. They serve two different purposes. There's no overlap, and so I like to keep them separate. If you have the same person that you want to name for both, great. You're still going to have a financial power of attorney and a healthcare power of attorney. They're going to be separate even if you have the same person named. So let's talk about in general how these documents work, what purpose they serve. So sometimes there's confusion as to when the power of attorney is effective, and sometimes I'll have someone come to me and maybe somebody's passed away and they're like, well, I'm power of attorney, so I can handle their financials, I can handle their bank accounts, right? And the answer is no. The power of attorney is only valid during someone's lifetime. Once the person has passed away, that power of attorney is null and void. It has no effect at that point in time. Once the person has passed away, then it's their will, then it's their trust that decides what happens with their estate. So the power of attorney is only effective during one's lifetime. And generally speaking, and how we prepare them is that they're only effective upon your loss of capacity. So if we are preparing power of attorneys for you as part of your estate plan, it's going to say that these power of attorneys, the people that you have named to make these decisions for your health care and for your financial, handling your financial affairs, they're only effective upon your loss of capacity. So it could be short term, like an accident or an injury, or it can be long term. More commonly, we see that with like Alzheimer's or dementia. Okay, so while you have full capacity, while you have the ability to make your own decisions, you make your own decisions. The person named as your power of attorney does not have any power to make any decisions for you until you've lost capacity. So how does that happen? If you lose capacity, how does that person have the ability to make decisions? How it works is that with that power of attorney document, it specifies that it requires something in writing from your doctor confirming that you have lost capacity. So if you don't have capacity anymore, again, whether it's short-term or long-term, your attending physician, whoever that may be, is going to write a letter confirming that you don't have capacity to manage your own affairs. That letter from the doctor plus your power of attorney document, those two items combined, is what's going to allow your power of attorney to take that to your bank, to handle your banking, to provide that to any other doctors or nurses or labs or any other healthcare professional to have access to your healthcare records and to make decisions for you. That's how they're able to make that decision. Another question I get a lot of times when I'm doing estate planning is, where are these documents? So when we prepare your estate plan, you get all of your originals back. We prepare an estate planning binder for you that has your originals, instructions, what to do, things like that. But you want to ensure that you're keeping your estate planning binder somewhere that's safe, where the people that you've named as your power of attorney, as your executor, as your trustee, as the guardian for your minor children, they need to know that these documents exist and where they are. If you keep them in a safe at home, make sure someone else has the combination. If you keep it in a safe deposit box at a bank, make sure you have somebody else named to have access to that box to get access to those documents. So that's very important that you keep them safe, but also the people that need to know and have access to those documents, that they know where the documents are and have access to get them. So that's a short summary of a healthcare power of attorney and a financial power of attorney, why we keep them separate, how they work, when they work. So we include those documents with our estate plans. Whether you're doing a will-based plan or a trust-based plan, we include those power of attorneys unless you tell me, Darcel, we don't want them. If you don't want them, I'm going to highly encourage you that while we are doing your estate plan, we really should do power of attorneys. If we're gonna do your estate plan, let's do it right. But sometimes clients will come to me and they already have a power of attorney and we're just doing a new will or doing a new trust. So in that scenario, if you already have power of attorneys and they're accurate, you don't need any changes to them, great. We'll only do the will or trust or whatever else that you may need for your estate plan. But when we do an estate plan at our office, we want to make sure that when we're done, you have a full and complete estate plan. That doesn't mean it's complex. A lot of our estate plans are very simple. Some clients do have more complex needs and they have more complex estate plans. But whatever the situation is, whatever your needs are, I want to ensure that you have a full and complete estate plan that reflects what you want and will ensure that your estate and your affairs and your loved ones are taken care of if something were to happen to you. So if you need help with your estate plan, if you need some updates, or if you don't have an estate plan but it's been something on your to-do list, it's something that you know you needed to get done and you want to get it done but you just haven't done so, give us a call, send us an email. I'll have our contact information below. Now, I'm only licensed in Washington State. So if you are outside of Washington State, I would love to help you, but I cannot do so. I'm only licensed in Washington. So I would encourage you to contact your state bar association to get a referral. But if you're in Washington State and you want help with your estate plan, reach out. I'd be happy to help you. Our contact info is below, and I'll see you in the next video. All right, thank you.